everyone to the Children's Policy Centre webinar series. I'd like to begin by acknowledging the Ngunnawal and Ngambri people, the traditional custodians on the land which I am broadcasting from today, and pay my respects to their elders, present and emerging, past, present and emerging, who have never ceded sovereignty and remain strong in their enduring connection to land and culture. My name is Angie Bexley. I'm Deputy Director of the Children's Policy Centre based here at the Crawford School of Public Policy at the Australian National University. This is the second in our series of webinars at the Children's Policy Centre, marking 30 years since Australia ratified the Convention on the Rights of the Child, also known as the UNCRC. Last week we had Professor John Tobin, who provided us with an overview of how far Australia has come and how far we still have to go in progressing children's rights. We hope you can join us also next Thursday at 1 p.m. for our third webinar on the CRC and child protection in Australia. The topic for this week's webinar is the age of criminal responsibility in Australia. The minimum age of criminal responsibility here, which is just 10 years in most jurisdictions, has long been an issue of concern in Australia and one that requires consideration from the perspective of children's human rights. Over the past year, it has been the subject of a campaign to raise the age, resulting in the minimum age of criminal responsibility being increased here in the ACT, but not yet in other jurisdictions. We are very fortunate today to have two guests with us to walk us through these recent debates on the age of criminal responsibility in Australia and what the Convention on the Rights of the Child and a human rights lens brings to these debates. Sophie Trevitt is a solicitor, campaigner and strong advocate for reforming the justice system. Sophie is the Executive Officer of Change the Record and the ACT Co-Chair of Australian Lawyers for Human Rights. Sophie left a career in politics in Canberra to go out west to Alice Springs in 2016. She practiced in a wide range of civil and administrative law before managing the youth prison and police accountability practice for an Aboriginal legal service in Alice Springs. Sophie began work in Alice Springs as the Royal Commission into the detention and protection of children in the Northern Territory was underway. In her time practicing as a lawyer in Alice Springs, she was not aware of a single non-Indigenous child that was incarcerated in the Alice Springs Youth Detention Centre. Dr. Faith Gordon, who is a senior lecturer in law at the Australian National University and director of the Interdisciplinary International Youth Justice Network and an associate research fellow at the Information Law and Policy Centre, Institute of Advanced Legal Studies in London. Faith has previously worked as a lecturer in criminology at the University of Westminster and Monash University. She was a postdoc research fellow in law at Queen's University in Belfast, working as a lead researcher on an ESRC knowledge exchange funded project. Faith's first sole authored monograph titled Children, Young People and the Press in a Transitioning Society, Representations, Reactions and Criminalisation was published in 2018 as part of Palgrave's Macmillan's socio-legal series. Sophie and Faith, welcome to you both. Today's webinar will be in the form of a conversation and I'll now hand you over to Professor Sharon Bessel to facilitate. Thank you.
Thank you so much, Angie. Welcome to everyone. Welcome to Sophie and Faith, and thank you for joining us today. We're going, as Angie said, to have a conversation rather than traditional presentations, and we invite the participants to join the conversation and to put any questions or comments that you have in the Q&A section of the Zoom. I should also add that we are recording this and this conversation will be available on the Children's Policy Centre website early next week. So Sophie, perhaps if I could begin with you. Can you tell us exactly what minimum age for criminal responsibility is and what the implications are?
Sure, thanks Sharon. So I'm also zooming in from Ngunnawal country in Canberra, and I pay my respects to elders past, present and emerging. So at the moment in every state and territory, still including the ACT, they haven't changed laws here yet, but they have committed to doing so, is 10 years old. So children as young as 10 can be picked up by police, handcuffed, taken to police stations, held in a police cell overnight or over the weekend in some jurisdictions, appear before court and be remanded or sentenced in juvenile detention facilities. So the implications of that are extremely serious, both for the child and for the entire community. So for a child, there's been extensive research that shows that the younger a child is who comes in contact with the criminal legal system, the more likely they are to have future contact. So with the Victorian Sentencing Council did some research that showed with every year that a child is sort of delayed from contact with the criminal legal system, it reduces the chance of them reoffending, violently reoffending, and becoming, in effect, a form of institutionalisation as they become habituated to this contact with the criminal legal system. So there's that element of it where the system plainly doesn't work. There's also the side of it which is that the younger a child comes into contact with the criminal justice system, the more likely it is that they're going to sustain lifelong harm. So we know that when children are very young, their brains are in the process of developing, and there's a whole lot of cognitive growth and maturation that takes place right up until you're in your mid-20s, but particularly at that pivotal time in your early adolescence. So when you lock up a 10-year-old child, you massively increase the risk that they're going to acquire mental illness, they're going to sustain further trauma, they're going to disengage from education, they're going to find it harder to learn in the future. And we know from mapping the trajectory of some of these kids that they are more likely to end up unemployed, to find themselves homeless, and even to die prematurely. So the consequences for a child are extremely serious and often lifelong. And I guess the final bit is for the community, it's also extremely serious. So for families, you have children being taken away from their parents and the people who love them. That's obviously extremely damaging. You have kids being taken out of their school environment and out of their overall community. But because we know that the earlier a child comes in contact with the criminal justice system, the more likely they are to offend, we're actually doing nothing to keep the community safer. So it's a system that is really letting everybody down.
And Sophie, I'm really struck by the comment that Angie made in your introduction, that when you were working in Alice Springs, you didn't come across a non-Indigenous child that had been incarcerated. And so I guess we have the added layer of this, of what one could almost describe as another stolen generation playing out in front of our eyes.
Yeah, and again, I think there are two elements of that. The one element is the child removal part of it. So we know that there is an extremely strong connection between kids that are removed from their families by child protection services and those kids coming into contact with the criminal justice system. So that's one element. And then the other element is both systems are highly racialized. So in the NT, when I worked in Alice Springs over a number of years, I never saw a non-Aboriginal young person in the Alice Springs Youth Detention Centre. I believe that at one point there was a non-Aboriginal young boy in the Dondale Detention Centre, but we're talking by and large, these are Aboriginal kids. And that isn't a coincidence. You know, that is a consequence of a series of discriminatory and systemic failures that sort of begin very early on in the space of child removal, what sort of health and support care are given to different communities, what sort of access to education there is, all that front end side of things, right through to police, who are police targeting. We've heard some really, disturbing revelations from New South Wales with their suspect management target list, which effectively is a list of young Aboriginal kids that are targeted by police. In Victoria, we know that they have a bunch of preemptive management sort of, technologies or ways that they collect data to try to anticipate whether young people are going to commit crimes, which we know that these systems are more likely to target certain groups of people. So Aboriginal and Torres Strait Islander kids are one of those groups. Also migrant communities are another group. And so we see these communities then overrepresented in the criminal justice system.
I wanted to just step back for a moment from minimum age of criminal responsibility specifically, and perhaps look more broadly around some of the issues of children and their human rights within the justice system. And Faith, perhaps I could draw you in here. We are holding this webinar series to mark Australia's 30th anniversary of the ratification of the Convention in 1990. And when Australia ratified, it was with one reservation, which means that Australia, as the ratifying country, didn't agree to that specific article. And that declaration was around Article C. And I'll just read Article C out, Article 38C. Faith, correct me here, is it 38C?
37.
37C, sorry, Article 37C, which is every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner that takes into account the needs of persons of his or her age. In particular, every child deprived of liberty shall be separated from adults while in detention, unless it is considered in the child's best interests not to do so. And the child shall have the right to maintain contact with his or her family through correspondence visits, save in exceptional circumstances. Now, while Australia has stated that it agrees with the general principle, the declaration states that it may not always be feasible to separate children from adults and to maintain contact with families at the same time, given Australia's geographic circumstances. Faith, how important is it that this declaration remains in place? And how much has that shaped the way in Australia that we think about children who are incarcerated?
Thanks, Sharon. I'm based in Melbourne, and I would like to acknowledge the Wurundjeri people of the Kulin Nation, who are the traditional custodians on the lands on which I'm based. And I'd like to pay respects to elders past and present, and extend this respect to all people who might be participating today or who will listen to the recording after the webinar. I think it's a really important question and something for us to consider, Sharon. Firstly, I'd kind of make the point that ratification of the Convention on Rights of the Child is one thing, but the implementation of it is quite another. And while Australia did formally accept, and that the acceptance of the obligation has been described as a relatively straightforward process, but the transformation of the Convention, the many provisions into domestic Australian law and policy and practice is where the really important work and impact can rest. And Philip Alliston and Glenn Brennan at the time wrote that that's infinitely more complex and more demanding. And I think it goes right to the core and the heart of what sort of a society that we want to live in, and what political will there is to fully embed a human rights and in particular a children's rights framework in Australia. And as you mentioned, Sharon, it was Michael Duffy, who was then I believe the Attorney General back in 1992, that stated that while Australia, did accept the general principle of Article 37, there was this point about how feasible it would be to separate children from adults, and also about that maintenance of contact given the geography and the demography of Australia. But lots of the available research and evidence demonstrates that children who have been the victims of abuse or violence at the hands of adults should be incarcerated in environments whereby they are separate from adults. And there are many, many reasons for that. And we've seen that that hasn't been the case here in Australia. Queensland, in relation to the report regarding the watch houses, there was clear evidence to show that that has not been the case, and the damaging ramifications that that has had for those children. First of all, though, the convention as well states that depriving a child of their liberty really is only meant to be in the most extreme circumstances. So many children and young people, and I know Sophie touched on this point, should not actually be in these environments in the first place. And facilities as well, in terms of their design, should children be incarcerated, they should be in facilities that are tailored to their needs. That's in relation to their age, to gender, and other various needs. And in terms of the connection with, family, evidence shows through the voices and experiences of children and young people who have been denied that ongoing access to family, to friends in the community, to their culture and to their country, that can have a really long-term damaging impact. I think that Australia needs to rethink and to have more vision on this, and in terms of the actual principle of the convention is there for a reason in terms of the well-being of children. It's not conducive to their well-being and health to be separated from culture and country and families. And we've seen these issues arise during the pandemic quite acutely in relation to the confinement of children and young people in lockdown situations where the access to visits from family have been severely restricted. We also know that children that live in rural and regional areas, for example, court hearings and where they are incarcerated is often at a huge distance from their family, from their connections, and that can have hugely detrimental impacts on them and also the wider circle that they have. So really huge issues in relation to that, and a real need to rethink the initial imprisonment of children in the first instance.
Faith, just to follow on a little further, the first sentence of that article, that relevant article 37C that I read out, requires that children deprived of liberty are treated with humanity and dignity. And you've already started to kind of go to these issues, but in your assessment, how well is that article consistently upheld in Australia?
It's really not. And we have an entire evidence base of clear examples. Many the testimonies, so the words of children and young people themselves who have been experiencing what they have been experiencing and continue to do so, about how unfairly treated they have been right the way from contact with police all the way through the criminal justice system, and they haven't had their dignity respected at all. In 2017, as you mentioned earlier, the Royal Commission into the Protection and Detention of Children in the Northern Territory really did shine a light quite clearly onto very, very serious violations of children's rights in the youth justice system there. And it found, like, for over a decade that children in the NT have been frequently mistreated, abused, humiliated, left alone for long periods of time. And the local government there has done very, very little to address these issues. We did have a lot of media attention and focus given the Four Corners report that was done. And there was a lot of media attention at the time on that. But we have to be asking questions about, how many more reports do we need? How many more pieces of evidence do we need to actually see some change happening? And we know from the official statistics that there are rising numbers of children being remanded in prison rather than being granted bail, and there's quite recent statistics released on that, and that's quite clearly contrary to international guidelines as well that say that prison should really only be a last resort for children. So there are really serious issues in relation to that, and there really is a very large now evidence base of examples. And I think that, given also to reports from the Children's Commissioners in various states and territories that include the voices of children and young people, they really need to be heard, and there needs to be the political will on the part of all of the governments and collectively in Australia to bring about change. We don't need any more report. The evidence is there, really.
Sophie, can I bring you back in now to talk perhaps a little bit about your experience as a lawyer who has represented young people in both the ACT and the Northern Territory, to share with us your experience around whether young people, I think we've already heard from Sophie, from Faith, that young people are not treated with humanity and dignity once they're within the legal system and within youth detention. But can you share with us some of your experiences around that issue, whether you see differences across jurisdictions or perhaps differences in the way that particular groups of children are treated within the system?
Yeah, sure. So I have worked in the ACT and the NT, but predominantly my work with children was in the NT. So I will talk mostly about that, but you know, we have seen similar reports, as Faith said, right across the country. So there have been reports from Queensland, WA, big court cases in Victoria. The ACT has had its own scandals that demonstrate the mistreatment of young people in detention centres, and certainly the type of footage and evidence that people would have seen coming out of the Four Corners and the Royal Commission in the Northern Territory is indicative, I think, of a broader problem within the criminal justice system and the youth detention system. I think at a very fundamental level, you know, the mistreatment of children comes from the fact that the criminal justice system is designed for adults, right through from the point of contact with police, you know, through to the court process, and then eventually in detention facilities themselves. So for those who haven't maybe been in those kind of environments, police cells are extremely loud. They're very stressful. They often have people who are intoxicated in them. They're concrete environments. Holding a child in a situation like that for any length of time is pretty traumatic. In the NT, it was very common for precisely what Faith was talking about to occur, which is children to be held in close confines with adults. They might be adults who are, you know, heavily intoxicated, that have mental illnesses and in states of distress. So that's obviously a scary and inappropriate environment for a child to be in. Courtrooms are also adult places. You know, I had a number of disturbing experiences with young people who clearly just had no idea what was going on. So, you know, one that springs to mind was an extremely young person. I think he was 11, he may have been 10, who was playing with a transformer doll under the bench, and had no idea what the judge was saying to him. Really wasn't in a position to give his lawyer instructions. Because he was just too young. He was too young to understand the implications of what was going on, what his role was, what the difference was between him doing something that was naughty, that his parents would get him in trouble for, and something that has ended up with him in a courtroom. Then the prison environment itself, or the youth detention systems. Again, I think some people potentially have, you know, a rose-coloured sort of view of what these places might be like. In the Northern Territory, the Alice Springs Youth Detention Centre is a very small facility. It's made of concrete. It has a small area outside where the kids can play basketball, usually. That used to just be concrete. It now has turf, but it used to just be a concrete sort of patch. It has a very small classroom that is frequently over capacity, so they can't fit all the kids in the classroom, so some kids don't get to go to school. And it used to have these sort of little quarters out the back where girls would stay because there were so few girls that were incarcerated. And it has sort of one big open rec room where you eat your meals and you know, can spend some leisure time. The physical environment of a facility like that Alice Springs Youth Detention Centre, in my view, is like the absolute, I guess, that's the first level of mistreatment that happens. So because it is so small, it's made out of concrete, it has nothing in it that is suitable for a child. You have, in some cases I know of, there were 5, you know, sort of teenager, young adolescents who are packed in a cell. So that means that there are mattresses put on the floor because there aren't enough beds for those kids. There's a single cell toilet in each cell. So these mattresses are around the base of the toilet. And these kids are required to spend almost 24/7 in that environment, close confines, no time to be by themselves, to have private conversations, to have a bit of a breather if there are tensions. That's not an environment I think that any of us who know teenagers can imagine a teenager coping in. So as a result of that, you get heightened levels of frustration, of agitation within these environments. You then have understaffed, under-resourced facilities, and staff that are not properly trained in things like working with young people, particularly young people that might have some trauma or some other issues going on, which makes these environments extremely volatile. So instead of children being cared for, being put in appropriate places with mental health supports, with family, they are effectively, compacted into this pressure cooker where it's almost inevitable that there are going to be altercations between staff and kids and between kids, creating an extremely unsafe and distressing environment for everybody. And that's the norm, I think. I don't think that there's nothing external has to happen for that to take place. And then in the NT, you have added on top of that a bunch of other really unacceptable practices. So, for example, when I worked there, they were so short-staffed that for a period of time, bouncers from the local pubs were brought in to serve as staff effectively within these facilities. So these are people who have no relevant training, not trained to deal with young people, are trained to be the big burly guy on the door dealing with intoxicated adults. That's obviously inappropriate. And resulted in, complaints of racial harassment, complaints of assaults and batteries, some of which were serious from my child clients. The other extremely distressing thing that is, again, the norm around the country, but we saw in the NT frequently, was because of these difficulties with staffing, and because as Faith and others have commented on, because we have so many children in these facilities, children are not being given bail, that alternatives to prison aren't being used sufficiently. So because they're overcrowded, lockdowns becomes the way in which these detention centres manage kids. And that's when you effectively lock a child, or usually multiple children, in cells for long periods of time. This was probably the thing that I got the most complaints about. And I think it was the thing, even more than the assaults or batteries, was the thing that seemed to do the longest and the most profound damage to kids. Being locked down in a room where they couldn't move around freely made the kids feel, in their words, like they were going crazy. They were sometimes denied access to family over the phones. They couldn't even talk to people about what they were experiencing. So this led to incidents of self-harm and aggression and threats of suicide, because these kids were just feeling so desperate in situations which are inappropriate for anybody. Adults also struggle when prisons are put into lockdown, but certainly not appropriate for very young children. I think the final thing that I'll say is there's a myth in the community that youth detention centres are places where rehabilitation can take place. That has not been my experience. I've never seen a youth detention centre that is rehabilitative, but certainly in Alice Springs, the lack of resourcing meant that there were really no structured activities at all for kids. So their options in a day was to be in their cell. If there was enough resourcing, they could go to school for some of the day. But, there's been public statements by the independent visitor that show that, kids were only going to school about half the time because the other half they were in lockdown. And the structured activity that was available to kids when I was working there was called Work Party. And Work Party was cleaning the facility. So there was no training for future jobs. There was no, maybe assistance around, I had one child who asked for assistance around anger management, and so wanted courses to participate in or someone to help and coach that young person. These sorts of things were not available for these kids. So instead of being rehabilitative, these are punitive places, but of the most acute degree.
And presumably reinforcing any of those behaviours that we would want to change through rehabilitation, that actually those behaviours are being entrenched by the experiences that young people have. Sophie, I don't think anyone listening can listen to this without reflecting on what a national disgrace it is that this is allowed to continue in the face of what we know through report after report and through the incredible work that people like you, Faith, and others have been doing. I was really struck by the comment you made about bouncers being brought in when staff was short, and I think that speaks for itself in terms of the kinds of relationships, if you could call it that, that are developed between children and the people who are charged with looking after them, if you can use that term. But I wonder, Sophie, if you could say a little bit about the other kinds of relationships that young people in these situations have as they go through the process with the police, with their lawyers. I think young people who find you as their lawyer are probably incredibly fortunate. Perhaps not everyone is so fortunate to have a lawyer that is responding to their needs as a young person. What the relationships are like with the judges that determine what their fate will be. Could you just talk us through that a little bit?
So one thing I will say is that one of the most sort of human and sort of distressing and how basic it is, things that would often happen in Alice when I'd be getting statements from kids about mistreatment, about things that happened, and trying to identify who were the staff members that are subject to the complaint. And kids would often be at pains to tell me which staff were good. And the way that they described, like, the thing that made a staff member good was that they would call them by their first name, that they felt like they would listen to. So a really common thing that kids would do that would get them in trouble is they would either bang a lot at night on the cell doors to get attention if they wanted a glass of water, for example, or they would block the toilet in the cell if they felt that they weren't being listened to and cause a flood. And so they would describe these practices as things they would do because basically the adults that were meant to look after them weren't looking after them. And so when there was a staff member or a guard who was attentive to these kids' needs, that was profound. That had a really significant impact on that child. And I'm not talking about, copious displays of affection or anything like that, just basic human dignity, treating kids as though they're worth listening to and that their concerns are valid, and doing things like trying to make sure they had contact with family, for example, was a big one, which can sometimes be a bit difficult if parents don't have mobile phones. Staff that would go to the effort of trying to facilitate that contact for kids were hugely appreciated. So I think that's the first thing, just to sort of indicate actually how basic the wants were of some of these kids. In terms of the relationships and dynamics with other adults, I think it is true, the idea that for a kid to do something seriously wrong, which is rare, most of the kids in prison haven't done things that are seriously wrong, certainly not violent things, but for those who have, they've been seriously let down, usually by a lot of adults. And so that often starts in the education system, where they'll have difficult relationships with peers and adults in that environment that have then resulted in them getting suspended or expelled. That's often the first step to someone coming in contact with the criminal justice system. And that's not hard to understand, I don't think. If a kid isn't participating in a structured activity during the day, what are they doing? In Alice, there isn't that much else for them to do, so they're roaming around and, doing naughty things like throwing stones or graffiti or whatever that end up with them coming into contact with police. So instead of a response to that being, let's get the teachers and the parents and maybe a social worker in a room and try to work out why this kid is disengaging, instead the response is call the police get involved. In Alice, as we know from the evidence around the country, in lots of other places, this is a highly racialised situation. So it is Aboriginal kids that are getting picked up as opposed to non-Aboriginal kids. We know that this is the case across the country, particularly for very young kids. So very young children, so those under the age of 14, are even more disproportionately likely to be Aboriginal or Torres Strait Islander when they're picked up by police. We also know that police are more likely to formally charge an Aboriginal or Torres Strait Islander child than they are other children. So non-Aboriginal children might get a warning. They might not get anything. They might just get told to go home. They might get a formal warning. They might get a diversion that doesn't involve the court system. an Aboriginal or Torres Strait Islander child is more likely to be formally charged. They're more likely to be handcuffed, to be taken into lockup, and then to be brought before a court. So that's a very different treatment right at the very beginning of that interaction. Then within a courtroom, this I think does really differ depending on jurisdictions. So some jurisdictions have children's courts, which is a particular environment where kids are, you know, in an ideal model, you have kids and the judge and family members all involved in sitting around a table. As far as I know, that is not something that happens in lots of places. In the Northern Territory, it certainly doesn't. While I was there, I understand they're developing a children's court now, but when I was there, the children's court consisted of the adult court, and the judge, seeing that they have a child coming before them, would walk out of the room, would then walk back into the room, and then declare the opening of the children's court. So it is the same judge who's just heard adult matters, who is then meant to, within a matter of seconds, change their mindset over to be dealing with a child. And without even casting any, you know, aspersions on that judge, that is an extremely difficult thing to do when you've been hearing about serious crimes committed by adults all day. It's also not an environment that's suitable for a child. So that's an environment where, you know, the judge is sitting up high. There are lots of people in formal outfits around the room. Unless the court is closed, there's potentially members of the public sitting in the courtroom. And then there is a very young child who's in this extremely intimidating environment. So that potentially is a very scary, if not just completely sort of incomprehensible environment for a very young person to be in. Before or after that, the kid will be in the in the police lockup itself. When I worked as a solicitor in the NT, I got lots of complaints, and we brought lots of actions about conduct that happened in the police station itself. So as I sort of said earlier, these are extremely volatile places. They are places where police are used to dealing with adults. They don't have a huge amount of time or patience for very young people who might be distressed and noisy and wanting things like food or contact with family. It's certainly not a good environment for lawyers to be in when they have to seek instructions from clients, which is frequently the case. Trying to get instructions, as we say, from hear the story from a child is difficult at the best of times. Children are often extremely honest, but they are also extremely non-linear in the way that they want to tell you about something that happened to them. They want to tell you the bits that affected them the most and that were the scariest and the most important to them, and that might not be what you need to take to court to say whether or not the child did what they've been accused of doing. So instead of being able to go through that process in a calm and supported way, you might have 15 minutes to do that before you're meant to appear in court with your client. The child may have also had, confronting or aggressive or inappropriate contact with police, and you're somehow meant to be hearing about that from the child in a situation where the police are there. So that's all extremely difficult in a practical sense. And then there's the youth detention centre itself, which I've talked about. And I guess alongside that, the whole way through is for a large number of those children who have had contact with the child protection system, there's that element of it as well. And so that means members of, in the NT, it would be territory families, but in other places it would be other child protection services are often at the courtroom with the child, but they might also be the people that have called the police. So it's really common for kids to be criminalised because of conduct that has taken place in the home, so we say in the residential care unit that child is in, whereas if it was a child who hadn't been removed from their family, they might be at home, have a fight, pinch mum on the leg, something that I remember doing as a child and getting in trouble for, throwing a chair. One instance that my colleague dealt with was a child who got into a food fight, so threw food around, was then charged with property damage, then ended up in court. So the person who has called the police is then the person that is meant to be providing support and speaking up effectively for that child. So in all these ways, you have these adults and these institutions that are coming in contact with these children in ways that are both inappropriate, but also not in the best interests of that young person.
Faith, I mean, we've just heard about such a litany of what I think we can only call abuse, and a system that is fundamentally broken. If we start to think about how we fix this, what are some of the principles of a rights-based approach to youth justice that we need to start to put into place in Australia? Now, what are those principles, and how would Australia's system start to look different if we did put those principles into place?
Sure. Thanks, Sharon. In terms of the UN Convention, I'd probably make a point, first of all, to say that the UN Committee do come and, investigate what the progress has been in relation to countries in upholding and protecting the rights of children and young people. And Australia very recently had that process, and the UN Committee report of 2019 made a number of really, really significant suggestions and recommendations. And those ranged from the topic that we've touched on today about raising the minimum age of criminal responsibility from 10 to 14. So they were extremely critical of Australia for not having done that. They also made a number of recommendations about prohibiting the use of isolation, like as what Sophie mentioned there, and prohibiting the use of force against children in detention, including the use of restraints, and also recommending that any cases of abuse or mistreatment are immediately investigated. And they also urged places like the Northern Territory and Western Australia to review and repeal mandatory minimum sentences for children. There are only a few of quite a raft of recommendations that the UN Committee made. The report card that Australia got was very, very serious. And, we need to be seeing movement. The committee have spent the time. We've had reports from the children's report coordinated by UNICEF that was also submitted. And I'd urge people to read that, in terms of the fact that it also features children and young people's voices. So there are, from the committee's perspective, a whole raft of things that need to change. In terms of what a rights-based approach to youth justice might mean or might look like, well, upholding those key principles of the convention is a starting point, and also to ensuring that one thing that, as a researcher, I hear time and time again from children and young people is that they just do not feel that they are being heard on what's happening to them, what the issues are for them. And I think that that's really central. They are children. I think that in terms of the representation of children and young people in detention, the media and politicians and wider society have a huge part to play. The labelling of children as, youth offenders, etc., can have a huge, huge impact upon the way in which those children view themselves, view their peers, and can have a lot of long-term consequences for when they do come out of the juvenile justice centre and go back into their community. And I've spoken to hundreds of children and young people about that type of language and the impact that it has. We really, really need to be changing the discourse on all of that. Another key point that Sophie mentioned earlier was about, the lockdowns. And we've seen that the media angle on this has been that, young people are attacking staff. This has been the kind of tabloid press representation of that. But all of the context surrounding why children and young people have protested is about how they're being treated. So I think that, these messages and the voices of children and young people really need to be at the centre of everything. I think another key point, building on what Sophie mentioned, is that there are legacies in communities. The current generation, the generation before that and before that, have also experienced differential policing, racism, targeting, child removal. there are intergenerational legacies in relation to that and in relation to trauma, and these really need to be recognised. Australia really needs to be having those big conversations, but they need to be also community-led. You know, what would communities like to see? And I think that the convention itself, as we've mentioned, you know, detention should be a last resort. You know, there are many examples of diversion programs that have been, you know, designed and advocated for in terms of First Nations communities here in Australia. And, you know, those programs should be given resources that they need. Many people, you know, speak about how effective those are, that communities know what works for them. And I definitely think that, you know, communities need to be at the centre. You know, we've had, you know, as I mentioned, that legacy is an issue, and it needs to be addressed. And the current generation are really paying the price for what has happened to a previous generation, etc. as well. So the principles of the convention and the articles within it, I feel really need to be embedded in every aspect of, you know, from all government policies and practices to the way in which, you know, the education system is run, to the way in which, you know, children are valued for the contribution that they make in their communities. And, you know, the fact that, you know, laws currently allow for physical discipline of children as long as it's reasonable in the circumstances really shines a light onto the position of children and those power dynamics that Sophie mentioned that operate, not, you know, just only at a community level, but right the way through the criminal justice system itself. We really need to be asking ourselves, I think, like I mentioned earlier, what sort of a society do we want to live in? And I think that's one example of just really the position of children. And we've seen that other jurisdictions, such as Scotland, have been, you know, striding forward in terms of making changes. And Australia can perhaps look to the frameworks that those countries and the reforms that they've been making. But one key point I would make in relation to that is that, you know, the context of countries are very different. And I would return back to that point about legacies and intergenerational legacies, and that things should be community driven and community led, with those voices at the centre of any reform.
We have in the audience Juliet Attenborough, who has her hand raised. Juliet, I'm just going to unmute you so you can ask your question or make your comment.
Hi, thanks so much. I actually didn't mean to raise my hand, but I did have a burning question, so I might just jump in. Really appreciate everyone's inputs. It's such an interesting conversation. And I guess one of my questions would be, what do you think it's going to take to get to the other side of those kinds of reforms in an Australian context, in terms of building the political will, but also building the technical solution so that people have the alternative pathways available to them? Thanks.
Thanks, Juliet.
Do you want me to jump in with an answer to that?
Sophie, that would be great, yes.
So I think there are two parts to the question. One is around what solutions are already there and what more work needs to be done, and the other being around what's it going to take to get politicians to make that leap. So we've, as part of the Raise the Age campaign, we've done a lot of work in both those spaces. My view is, and Faye sort of referred to this earlier when she talked about the evidence being there and all these reports, you know, having been done that have told us what we need to do to stop the massive incarceration of children. And that's true. Reports dating back to the Royal Commission into Aboriginal Deaths in Custody have documented a bunch of recommendations that we could put in place immediately that state, territory and federal governments haven't. It's also true to say that the Northern Territory government, which is, you know, is the subject of the most recent Royal Commission, has not only failed to implement a range of those recommendations, But during my time in the Territory, so just after the Four Corners episode aired, the Chief Minister at the time said this will never ever happen again, and some legislation was amended, the Youth Justice Act was amended to put in protections for young people, particularly around the use of force, the use of restraints like the spit hood that we saw a young Dylan Voller in, and the use of isolation and segregation. During my time practicing in Alice Springs, the NT government then repealed most of those amendments. So it went back to how it was before the Royal Commission, and effectively then re-exposed young people to the type of mistreatment that we saw aired on national television. So I think the first thing to say would be governments need to implement the recommendations that are already there. In terms of what the solutions are, there's also been a huge amount of work done over many, many decades, lots of it being Aboriginal-led work around community-based solutions. So there are some very successful justice reinvestment projects, for example, that deal with adults but have now expanded to children in New South Wales. There's also a pilot program in WA that I know has had great success. I think one of the real problems with this area is that politicians appear to be willing to fund pilot programs, so to fund a program to run for a few years, and they're not to give it ongoing funding. And this has two big issues. One is that it's difficult to prove the effectiveness of a program when its goal is to prevent recidivism and help a young person into the future. That requires a long lead time. So it's difficult for these projects to prove to government that they're working if they're not funded for a sufficient amount of time to prove that they are working. And the second element of it is that you don't have enough time for the community buy-in and support to develop if you don't fund these initiatives well from the beginning. So I think in, say, the context that we're in right now, when the Closing the Gap report the refresh has happened, it's been handed down, we've had promises from the government they're going to do things differently, work in partnerships with Aboriginal communities. What we haven't seen yet is what exactly is that going to look like? Is that going to look like dollars on the table for Aboriginal-led, community-driven solutions, and in non-Aboriginal communities for non-Aboriginal-led but still community-based, localised solutions that take into account the needs of that community and those young people? Or are we going to see just more of the same and that Closing the Gap aspiration remain an aspiration? So I think that's one side of what the sort of technical alternative is. What do we do if we're not putting these kids in prison? I think the other side of it is those systemic drivers that I mentioned before. So yes, we need to raise the age just because it is both unhelpful for the community and for the child to have those kids in detention. But we need to stop all those drivers that have gotten the kid to the point where they've been so let down that they're ending up in that kind of trouble. So that means massively having a rethink of our child protection system. This is an area where, so the ACT, we have very few young people in Bimberi, which is the youth detention centre here, but we have a huge number of young people, particularly Aboriginal and Torres Strait Islander young people, who are being removed from their families. So what can we do differently to not take kids away from their families, but instead to be investing in those families, investing in, again, community-controlled solutions to help those families stay together and strong, keep those kids connected with their culture and their identity. Just yesterday, the Royal Commission that's looking into disability and disability services heard from Aboriginal people in particular, and there were some really harrowing stories from Aboriginal mothers and parents who have mild disabilities, perfectly capable of taking care of their children, who had their children removed, basically a form of sort of proactive discrimination where government departments decided because you have a disability, you are not able to care for your child and remove the child. Those children then are separated from their families, and we know are at a far greater risk of not only having all of the trauma that comes with that, but also coming in contact with the criminal justice system. So the origins of how this inequity is sort of played out comes from all these different points of discrimination, both racially and on the basis of things like disability. So we need to zoom out, I think, not just look at what do we need to do to reform the criminal justice system, reform the concrete buildings themselves, but also what are the systemic factors that are driving these kids into the criminal justice system. I think the final thing that I'd say is the education system is huge. Suspending and expelling children is one of the key ways that you're setting kids up to fail. And so while that might, so part of that change might be what extra resourcing needs to be given to teachers so that when kids do act up, when things are difficult, we have teachers that are adequately supported to deal with those behavioural tensions or whatever it might be that is making it hard for that kid. But we also need to look at things like, why was all the funding abolished for bilingual education in places like the Territory where, say, most of my child clients didn't speak English as a first language? Why aren't we teaching in a way that is engaging for all members of our community and all kids, so that schools are safe cultural places for them to be? And that is in no way a criticism of teachers. That is a criticism of the lack of funding and resourcing that we are putting into kids, into young people that we're hoping are going to grow up into productive and you know, members of our community. So I think in terms of what the solutions are, unfortunately there's not just one simple solution, but it's that sort of broad systemic approach. And the very final thing I'll say is, while I you know, am really concerned about the lack of political aspiration to raise the age and to implement some of these reforms, it's very exciting what we've seen in the ACT and the fact that they've committed to raise it to 14. And we did some polling in July this year that showed that the majority of Australians do want the age to be raised to 14. So I think when Faith said that this also falls to the community, there is a huge role for us to play in showing members of parliament that it's not a political risk for them to do this. That communities want to be safe. They don't want to be torturing children in the process. They want governments and us to be investing in solutions that keep communities safe, families safe, and kids safe.
Sophie, thank you. You've, I think, mapped out what the challenges are, but where we can start. And it does seem that while raising the minimum age is only one small part of this, it is one small part that can happen very quickly, very easily, and immediately. And so it is beholden on all of us to support the work that you and others are doing to make sure that happens, and happens as soon as possible. We are almost out of time, and I feel like we've only just scratched the surface. Faith, I would just like to give you an opportunity in closing from your perspective in terms of what it is that we need to start to do first. What Sophie's mapped out is an urgent but also very large and long-term agenda. Do you have thoughts on where we start?
I think Sophie has mapped out so much, and there is so much work to do. I think, though, that the longer things are delayed and the inaction, there are obviously more children and young people being affected. I think that the frameworks, in terms of actually the domestic legislation and the frameworks, you know, there hasn't been that, you know, only a few states and territories have, you know, for example, Victoria has the Human Rights Charter. So we don't actually really have those embedded frameworks. And I think that, you know, the introduction of those and more, you know, we all need to engage with the human rights discourse and language because it is positive, you know, protecting and implementing that is a positive thing for everyone in society. And I think that there are other jurisdictions to look at in terms of what, you know, is happening in the youth justice space that's positive. So, for example, in New Zealand, there was reforms to their youth justice legislation where judicial officers, in making a decision, have to make that in light of the convention. So what we see is some emerging case law now, and I would encourage everyone to check out. I read two judgments by Judge Anthony Fitzgerald, who in his decision and in the judgment, he referred to the convention, he referred to the general comment. And, you know, as a researcher, you know, to read that, to see that the outcome for the child had been in light of the convention and the general comment is something that I think that other jurisdictions should be looking to. It is possible to do this. It's possible to bring in these reforms. It's possible to change the political scene and the way in which we refer to children more broadly in society. And also ensuring that I think that, you know, we do value the voices of children and young people. Everyone has the right to be heard. And I think that, ensuring that children have that stake and that platform, and that it's not tokenistic in its manner, is very important. We've seen, children lead the way in terms of, climate change, highlighting how far behind Australia are in addressing these issues. However, they've been met, with discouragement and with certain comments from key political leaders, including the Prime Minister. They're engaging with their rights, the environment, the future. And I think that, children and young people need to know that their voices are as valued and respected, and their opinions as anyone. So I think that there are key moves that we can make more broadly beyond the criminal justice system, and that all relates to the position of children and young people in society.
We are at 2 o'clock and it is time to end this. I think we would like to invite you both back into next year as the political discussions continue around raising the age, and to continue this conversation. I guess to everyone who's here today, I would say, if you're not already, and I'm sure people who are participating today are already supporting the Raise the Age campaign, please get behind it, please do so, please vocally support it. We will also be putting this recording, as I said, up on our website. Please share it with others. I think hearing what Faith and Sophie have shared with us today is so incredibly powerful in shifting some of that negative public discourse. And I think for all of us, we cannot continue to live in such a wealthy country, in a country that consistently ranks in the top 2 or 3 in terms of human development globally, in a country that prides itself on traditions of justice and egalitarianism, if we let the most vulnerable children be treated in this way. The Convention gives us one way of starting to move forward. It's been 30 years now and we've not taken the opportunity to do that, and it is time for us to do so. I want to thank you both, Faith and Sophie, so much for talking with us today, and to thank you for the work that you do and the work that your colleagues do. Unless a light is shined on these injustices, they will continue. And so thank you both so much. And thank you to everyone that joined us today.